Good morning. I thank the Chair for the opportunity to speak today. Specifically, my comments are related to pages 739 through 741 of the Ohio Budget Bill regards to park districts. Taken in the context of this bill, this small and seemingly innocuous change may seem rather trivial, but I submit to you that there are some significant implications affecting the liberties of the citizens of the state of Ohio. Ignore what people might be telling you in regards to what the intent of the law is. I ask that you read it yourself and ask the following questions. Can First Amendment rights be impacted by this? Could it be used to intimidate and suppress free speech? Would a citizen be negatively impacted by due process? And would this violate the separation of powers? If the answer to yes to any of these questions, then I ask that you reject this language. It's important for everybody to understand the background in which this change is being proposed. I have the honor and privilege of serving as a township trustee for Chester Township in Geauga County. For more than 30 years, we've had an arrangement with the Chester Park Board to manage township-owned properties known as Parkside. Last year, I voted against an agreement which contained certain terms and conditions which would have put me in contempt of court. Because of the ongoing interference of our probate judge in the relationship, I was also compelled to terminate the existing agreement, a document that had been in place for more than 20 years. In response to my lawful actions with these agreements, the probate judge has accused me of intimidation, fraud, and violating his constitutional rights. By refusing to submit to the probate court's directives and with nothing properly before the court, civil and criminal investigations were initiated against me personally by the probate judge. If this proposed amendment were law 2 years ago, I could be in prison right now, having faced a third-degree felony and up to 5 years in prison. I ask everybody to think about that. The job of the prosecutor is not the proper role for the probate court. If this language becomes law, the probate court will be the investigator, the prosecutor, the judge, the jury, and the executioner all in one, violating several constitutional principles. For this reason alone, the language should be removed. You're being misled if people tell you that this change simply codifies the unanimous Ohio Supreme Court decision. The only matter that was before the Supreme Court was whether a probate judge was patently and unambiguously lacked jurisdiction. The Supreme Court's ruling did not grant the probate judge the powers that are proposed in this rule. In fact, the scope of the authority of a probate judge over a township board of trustees is currently at the 11th District Court of Appeals. Any change in existing law at this time would be improper. I ask yourselves, if 87 of 88 counties don't have a problem with the current law, why the change? The media has also reported that this probate judge has drafted this initial language. Legislation is the responsibility of this body, not the courts. If change to 1545 is a good law, it should stand on its own, subject to public scrutiny. Buried in the Ohio Budget Bill is a disservice to the citizens you serve. Under RC 2101, there already is a mechanism for a judge to appoint a special magistrate commissioner for matters pending before the judge. And that's critical language, pending before the judge, because if nothing is properly before the court, then a judge could not hire a master commissioner. This change would allow the judge to initiate any investigation, compel anyone to become a party to the proceedings. It's cause for concern that the executive, judicial, and legislative powers are being combined under the probate judge. RC 1545 Park Board is a separate political subdivision. If they felt that they were being impacted wrongfully, they have the right to bring an action in court. This change to the law would enable a judge to act unilaterally without a matter properly being before the court. We're potentially left without a clarifying definition, subject to the whims of a probate judge to determine what constitutes interference with the park district's purposes. This rule is also in direct conflict with current law. Under 1545.36, citizens may petition their courts to place onto the ballot a motion to dissolve a park district. Certainly, dissolution of a park district could be interpreted as interfering with the park district's purposes, and therefore citizens that are lawfully petitioning their government could be found guilty. I ask this body, is this the intent of the rule? Each of you has taken an oath to uphold the Constitution of the state of Ohio and the United States, and I ask you to adhere to that oath and strike this language from the bill. Thank you for the opportunity to speak.
Thank you for your testimony. Questions for the witness? Representative Rogers.
Thank you, Mr. Chairman, and thank you, Mr. Rank, for coming in and testifying. Interestingly, in the Plain Dealer yesterday, there was an editorial, and at the bottom of the editorial page, it basically suggested that, given what is going on there, that the real authority for appointing a park commissioner should rest with the commissioners, the county commissioners. And when you consider that most of your other department or administrative heads are appointed by the county commissioners, this is kind of a unique power that's given to the probate courts. And so I'm wondering if you have any opinion as to that suggestion.
I had spoken with Senator Eklund about this issue, and he had done some research, and he had told me many years ago it ended up at the probate court because nobody else wanted it, was essentially the commentary that I understood it to be. When you think about the ability for the citizens to interact with the elected officials, I think a board of county commissioners might be a better mechanism because they serve 4-year terms, and then there's 3 people that are all serving, so you can have a majority decision to make some impacts and hopefully good decisions. Right now, with a single probate judge, and I'll give an example that our Geauga County prosecutor had given, a probate judge in Cuyahoga County is in charge essentially of a $100 million budget, appointing people that he or she would want to serve on that commission. And I think a greater level of responsibility and accountability would possibly be accomplished with county commissioners appointing a park board. Thank you.
Representative Sprague.
Thank you, Mr. Chairman. I was just wondering, I'm over here, and just wondering, we got some correspondence on this about a year ago in my office, and I don't really understand what the issue is of the park system in Geauga County, but what would you possibly be doing that would justify a third-degree felony, which, I mean, is a lot higher than, possession of heroin and a lot of other things within our criminal code? Can you explain that to us with the proposed language, and what you were doing before with regards to your duties in the park board?
Well, my relationship with the park board, Township Board of Trustees is a separate political subdivision, and so is the 1545 Park Board. The only relationship that we have with them is an agreement to manage parkside property. If we didn't have an agreement with them, they're a separate political subdivision, we're a separate political subdivision. But the judge has taken the interpretation that because 30 years ago we made application to create a park district, that we are now and forever parties to this case. And that, unfortunately, would actually hold us accountable if a park board operated improperly, financial mismanagement or something like that. Even though we have no authority and no responsibility, the judge is making the interpretation that we're still a party to the case and could be assigning costs to us. I can only speculate as far as what the cause for the allegations are, but I would believe it to be the termination of the not agreeing to a new contract because it contained terms and conditions that had been struck down by the judge. So if those were in a new contract, I'd be held in contempt of court potentially. And also because, I felt in the best interest of serving the citizens, we had to distance ourselves from what was unfortunately an adversarial relationship, and that was the need to terminate the current agreement.
Representative Sprague.
Thank you. So I guess my follow-up question is just very quickly. So this would affect any sort of township trustee across the state and potentially hold them as a party to, one of these park boards if they do any work with them?
Well, there's 2 different types of park boards. The 1545 is a specifically legislative created in one mechanism, and then there's also a 511 Park Committee of which the Board of Trustees essentially has direct control over them. So within Geauga County, I think there's just 3 or maybe 4 that are considered 1545 park districts. And I think the reason they were created, 33 years ago was at that time there was an opportunity to receive state funding through the Legislative Government Fund and the Ohio Library Fund. And so there was the expectation of, at least in our township case, $50,000 a year in perpetuity if they had created this park board. That money is down to about $12,000 now, which basically just covers the administrative costs associated with a 1545. So the benefit of a 1545 doesn't necessarily exist right now, but it wouldn't impact all townships.
Representative Patterson.
Thank you, Mr. Chairman. And Mr. Radtke, thank you for coming down and for your service to the good folks at Chester.
You as well.
My question is this. Typically, issues such as this do not bubble up to our level, especially with respect to Finance Committee and the budget. And yet the history of the park system is a long and storied one dating back to the early part of the last century. My question is this. Are you aware of any other time within, because I would assume you're a member of the Township Trustees Association, you've been there for a long time, Has there been any other incident of this magnitude anywhere else in the state? I mean, what makes this so special, and can you illuminate some of the history to it?
I'm not aware of any other situation, especially rising to this level of what I consider to be judicial overreach.
Thank you.
Any further questions? Representative Latourette.
Thank you, Chairman. Thank you for being here today. I really don't have a question. I just wanted to point out that Mr. Radtke is one of my township trustees, and I really appreciate him making the trip here today.
Thank you.
Seeing, Representative O'Brien.
Thank you, Mr. Chairman, and thank you very much, Trustee, for your service to your community. In the trustees' business, as you have conversations with other trustees throughout the state, have you heard from any trustees in the 87 other counties with a similar issue?
I've not spoken directly with any other township trustees. I was at a conference and it really hadn't been brought up, and basically I just kind of rely upon the media for raising any of those issues. So I've not specifically surveyed any other township trustees.
Okay, thank you.
Representative Sprague.
Thank you, Mr. Chairman. And just very briefly, does this have any sort of fiscal impact on the state budget?
No, not that I'm aware of. Well, with the exception of potential excessive litigation that might result if this remains part of the bill.
Seeing no further questions, thank you for
Thank you very
being here
much.
today. Next witness is Nancy.